Been spamming Destiny all day, even $2 donation. How the Fifth Amendment doesn't end all these... How does the Fifth Amendment not end all these stupid SEAL Team 6 hypotheticals? What are you talking about? You don't need to commit a crime for the commander-in-chief to kill you for matters of national security. There doesn't have to be a crime committed for the military to act against you. That was his last $2. Abraham Lincoln suspended habeas corpus. No? Yeah, he did, but I don't know what all the process for I just don't like to cite to things that I'm not intimately familiar with. I'm so hesitant to The Fifth Amendment is the right to life and liberty and stuff. Okay, I don't know how that impacts. Okay. Habeas corpus can be suspended during times of civil war. Okay, where was I? Sorry. First, in terms of probability, the threat of criminal liability is much smaller. In Fitzgerald, the threat of vexatious civil litigation loomed large. The court observed that, given the visibility of his office and the effect of his actions on countless people, the president would be an easily identifiable target for suits for civil damages. Actions on countless people could result in untold numbers of private plaintiffs suing for damages based on any number of presidential acts. In the civil context, the risk in the criminal context is only that a former president may face one federal prosecution in one jurisdiction for each criminal offense allegedly committed while in office. The majority's bare assertion that the burden of exposure to federal criminal prosecution is more limiting to a president than the burden of exposure to civil suits does not make it true, and it is not persuasive. Yeah, so this is my argument, where I was saying, if I had to choose between immunity from civil suits or criminal suits, I would want immunity from civil suits. It's easy to not commit a crime. It might be incredibly difficult not to open yourself up to liability from civil damages, right? That's why I agree with... I think this argument is much more persuasive. Second, federal criminal prosecutions require robust procedural safeguards not found in civil suits. The criminal justice system has layers of protection that filter out insubstantial legal claims, whereas civil litigation lacks analogous checks. To start, the Justice Department policy requires scrupulous and impartial prosecution founded on both the facts and the law. See generally the Department of Justice, blah, blah, blah. The grand jury provides an additional check on felony prosecutions, acting as a buffer or referee between the government and the people to ensure that the charges are well-founded. In a dissenting opinion, a criminal prosecution cannot be commenced absent careful consideration by a grand jury at the request of a prosecutor. The same check is not present with respect to the commencement of civil suits in which advocates are subject to no realistic accountability. Let's see, what would this even go under? There are many more safeguards and protections built into criminal suits versus private action. Wait. What Jody just linked in chat. Is there a football game going on right now? If the prosecution makes it past the grand jury, then the former president still has all the protections our system provides to criminal defendants. If the former president has an argument that a particular statute is unconstitutional as applied to him, then he can move to dismiss the charges on that ground. Indeed, a former president is likely to have legal arguments that would be unavailable to the average criminal defendant. For example, he may be able to rely on a public authority exception from particular criminal laws, or an advice of the Attorney General defense. See this argument. Okay. Let's see. This thing, explaining that public officers may be impliedly excluded from statutory language embracing all persons. If reading the statute to include such officers would work obvious absurdity, for example, the application of a speed law to a policeman pursuing a criminal or the driver of a fire engine responding to an alarm. See also memorandum from acting assessor interpreting criminal statute prohibiting unlawful killings to incorporate the public authority justification, which can render lethal action carried out by a government official lawful in some circumstances. And then footnote 4, Trump did not raise those defenses in this case, and the immunity that the majority has created likely will obviate the need to raise them in future cases. Yet those defenses would have protected former presidents from unwanted criminal prosecutions much more precisely than the blanket immunity the majority creates today. Fuck. If I read every day, do you think my voice will become more adapted to it? Jesus. If the case nonetheless makes it to trial, the government will bear the burden of proving every element of the alleged crime beyond a reasonable doubt to a unanimous jury of the former president's fellow citizens. If the government manages to overcome even that significant hurdle, then the former... Fuck, I didn't mean to push that. If the government manages to overcome even that significant hurdle, then the former president can appeal his conviction, and the appellate review of his claims will be particularly meticulous. He can ultimately seek this court's review, and if past practice, including in this case, is any indication, he will receive it. In light of these considerable protections, the majority's fear that bare allegations of malice would expose former presidents to trial and conviction is unfounded. God, that's such a stupid fucking quote. Bare allegations of malice would not make it out of the starting gate. True, it's not a civil case, it's a criminal one, which is why the Fitzgerald comparisons are so inappropriate, in my opinion. Although a private civil action may be brought based on little more than intense feelings, quoting Fitzgerald, a federal criminal prosecution is made of firmer stuff. Certainly there has been, on occasion, great feelings of animosity between incoming and outgoing presidents over the course of our country's history. Yet, it took allegations as grave as those at the center of this case to have the first federal criminal prosecution of a former president. That restraint is telling. Yes, this is what I said before. Like, if we were worried about infinite criminal prosecution of past presidents, well, why hasn't it happened yet? Apparently, it's been possible up to this point. Why hasn't it happened? That's a good debate question. We are so worried about presidents infinitely prosecuting prior presidents for criminal matters. Why has it not happened yet? Despite the Supreme Court, why has it not happened yet? Why was Nixon pardoned by Ford? Wait, no. Why did Ford find it necessary to pardon Nixon? And why did Nixon accept the pardon if Nixon believed he was immune to criminal prosecution? If the president was assumed immune from criminal prosecution for acts taken as president. Third, because of long-standing interpretations by the executive branch, every sitting president has so far believed himself under the threat of criminal liability after his term in office and nevertheless boldly fulfilled the duties of his office. The majority insists that the threat of criminal sanctions is more likely to distort presidential decision-making than the potential payment of civil damages. If that is right, then that distortion has been shaping presidential decision-making since the earliest days of the Republic. Yes! True. Although it makes sense to avoid diversion of the president's attention during the decision-making process with needless worry, one wonders why requiring some small amount of his attention or his legal advisor's attention to go towards complying with federal criminal law is such a great burden. If the president follows the law that he must take care to execute of Article 2, as Article 2, Section 3 says, he has not been rendered unduly cautious. Some amount of caution is necessary after all. It is a far greater danger if the president feels empowered to violate federal criminal law, buoyed by his knowledge of future immunity. I am deeply troubled by the idea inherent in the majority's opinion that our nation loses something valuable when the president is forced to operate within the confines of federal criminal law. So what exactly is the majority worried about deterring when it expresses great concern for the deterrent effect that the threat of trial, judgment, and imprisonment would pose? It cannot possibly be the deterrence of acts that are truly criminal. True. Nor does it make sense for the majority to wring its hands over the possibility that presidents might stop and think carefully before taking actions that borders on criminal. Instead, the majority's main concern could be that presidents will be deterred from taking necessary and lawful actions by the fear that their successors might pin them with a baseless criminal prosecution, a prosecution that would almost certainly be doomed to fail if it even made it out of the starting gate. The court should not have so little faith in this nation's presidents. As this court has said before in the context of criminal proceedings, the chance that now and then there may be found some timid soul who will take counsel of his fears and give way to their repressive power is too remote and shadowy to shape the course of justice. Quoting Clark v. United States, that was quoted in the Nixon case. The concern that countless and baseless civil suits would hamper the executive may have been justified in Fitzgerald, but a well-founded federal criminal prosecution poses no comparable danger to the functioning of the executive branch. Bum, bum, bum. Does diplomatic immunity grant criminal immunity? I don't know how diplomatic immunity works at all. Wait, what the fuck is this? Wait, what is this? The Friday show at the RNC in Milwaukee. Okay. Maybe. I don't even know what that is. Okay. Page 86. At the same time, the public interest in a federal criminal prosecution of a former president is vastly greater than the public interest in a private individual's civil suit. All 9 justices in Fitzgerald explicitly recognized that distinction. The 5-justice majority noted that there was a greater public interest in criminal prosecutions than in actions for civil damages. Chief Justice Berger's concurrence accordingly emphasized that the majority immunity was limited to civil damages claims rather than criminal prosecution. The 4 dissenting judges agreed that a contention that the president is immune from criminal prosecution in the courts, if ever made, would not be credible. At the very least, the Fitzgerald court did not expect that its balancing test would lead to the same outcome in the criminal context. The public's interest in prosecution is transparent. A federal prosecutor herself acts on behalf of the United States. Even the majority acknowledges that the federal criminal laws seek to redress a wrong to the public as a whole, not just a wrong to the individual. Such that there is a compelling public interest in fair and effective law enforcement. Indeed, our historic commitment to the rule of law is nowhere more profoundly manifest than in our view that guilt shall not escape or innocence suffer. The public interest in criminal prosecution is particularly strong with regard to officials who are granted some degree of civil immunity because of their duties. It is in those cases where the public can see that officials exercising power under public trust remain on equal footing with their fellow citizens under the criminal law. See, and then another court case cited, we have never held that the performance of the duties of judicial, legislative, or executive officers requires or contemplates the immunization of otherwise criminal deprivations of constitutional rights. In another court case, judicial immunity was not designed to insulate the judiciary from all aspects of public accountability. Judges are immune from Section 1983 damages actions, but they are subject to criminal prosecutions as are other citizens. We emphasize that and then quoting another case, we emphasize that the civil immunity of prosecutors does not leave the public powerless to deter misconduct or to punish that which occurs. This court has never suggested that the policy considerations which compel civil immunity for certain governmental officials also place them beyond the reach of the criminal law. Even judges, cloaked with absolute civil immunity for centuries, could be punished criminally. That's a direct response to the chatter that was saying earlier, don't judges have infinite immunity? Oof. The public interest in the federal criminal prosecution of a former president alleged to have used the powers of his office to commit crimes may be greater still. The president represents all of the voters in the nation, and his powers are given by the people under our Constitution. Anderson v. Celebrezze. When presidents use the powers of their office for personal gain or as part of a criminal scheme, every person in the country has an interest in that criminal prosecution. The majority overlooks that paramount interest entirely. They don't ever address this, ever. I think this is a key point. Arguably the most important point that never even gets touched on by Roberts in the majority opinion. Finally, the question of federal criminal immunity for a former president involves a countervailing Article 2 consideration absent in Fitzgerald, recognizing such an immunity would frustrate the executive branch's enforcement of the criminal law. The president is, of course, entrusted with supervisory and policy responsibilities of utmost discretion and sensitivity. One of the most important is enforcement of federal law, as it is the president who is charged constitutionally to take care that the laws be faithfully executed. The majority seems to think that allowing former presidents to escape accountability for breaking the law while disabling the current executive from prosecuting such violations somehow respects the independence of the executive. It does not. Rather, it diminishes that independence, exalting occupants of the office over the office itself. There is a twisted irony in saying, as the majority does, that the person charged with taking care that the laws be faithfully executed can break them with impunity. Wait, real quick, okay? Now that I have a better understanding of law and composition of government, people were saying before that, like, well, what if the president doesn't enforce the law? What if Trump doesn't enforce blah, 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 blah? And then people were saying it could be a constitutional crisis. What is the constitutional crisis? Isn't the alternative just impeachment? Don't we have a direct remedy for it? Pissman going hard in the trenches. Uh-oh. The crisis is that impeachment will never happen. But that's not really a crisis, though, right? That's just your people have fucked you over. The people have failed at that point then, right? If impeachment doesn't happen and people don't vote accordingly, then it seems like that's not a constitution. Well, it kind of is, I guess. The people vote for legislators to pass laws, and they continue to vote for them. But the legislators don't support impeachment, but the people continue to vote for the president. I guess that is kind of a crisis, huh? A little bit, sure. Care the laws, but okay. It does not. Rather, it diminishes that independence, exalting occupants of the office over the office itself. There is a twisted irony in saying, as the majority does, that the person charged with taking care that the laws be faithfully executed can break them with impunity. The case before us, the public interest and countervailing Article 2 interest are particularly stark. The public interest in this criminal prosecution implicates both the executive branch's interest in upholding presidential elections and vesting power in a new president under the Constitution, as well as the voters' interest in democratically selecting their president. It also, of course, implicates Congress's own interest in regulating conduct through the criminal law. Fitzgerald, noting that the case did not involve affirmative action by Congress, yet the majority believes that a president's anxiety over prosecution overrides the public's interest in accountability and negates the interests of the other branches in carrying out their constitutionally assigned functions. It is, in fact, the majority's position that boils down to ignoring the Constitution's separation of powers. Finally, in an attempt to put some distance between its official acts immunity and Trump's requested immunity, the majority insists that Trump asserts a far broader immunity than the limited one the majority has recognized. If anything, the opposite is true. The only part of Trump's immunity argument that the majority rejects is the idea that the impeachment judgment clause requires that impeachment and Senate conviction precede a president's criminal prosecution. That argument is obviously wrong. Rejecting it, however, does not make the majority's immunity narrower than Trump's. Inherent in Trump's impeachment judgment argument is the idea, yeah, true, because if Trump's argument was true, then you'd be saying, well, hey, listen, his official acts can still be criminally charged. They just have to be impeached first. But the Supreme Court, they say that, well, your interpretation is wrong, but also you can never be criminally charged with those acts, even if you are impeached, right? It actually goes further, really, but that argument is obviously wrong. Rejecting it, however, does not make the majority's immunity narrower than Trump's. Inherent in Trump's impeachment judgment clause argument is the idea that a former president who is impeached in the House and convicted in the Senate for crimes involving his official acts could then be prosecuted in court for those acts. See brief for the petitioner, and this is the brief then. The petitioner would be the person filing the case, which is going to be Trump, or in this case, Trump's lawyer. The founders thus adopted a carefully balanced approach that permits the criminal prosecution of a former president for his official acts, but only if that president is first impeached by the House and convicted by the Senate. By extinguishing that path to overcoming immunity, however, nonsensical it might be, the majority arrives at an official acts immunity even more expansive than the one Trump argued for. On the majority's view, but not Trump's, a former president whose abuses of power were so egregious and was so offensive even to members of his own party that he was impeached in the House and convicted in the Senate still would be entitled to at least presumptive criminal immunity for those acts. Separate from its official acts immunity, the majority recognizes absolute immunity for conduct within the president's exclusive sphere to constitutional authority. We should write that down. Impeachment must proceed. It's precede as comes before, not proceed, right? Precede any criminal indictment. Cannot be criminally charged. Separate from its official acts immunity, the majority recognizes absolute immunity for conduct within the president's exclusive sphere of constitutional authority. Feel free to skip over those pages of the majority's opinion. With broad official acts immunity covering the field, this ostensibly narrower immunity serves little purpose. In any event, this case simply does not turn on conduct within the president's exclusive sphere of constitutional authority, and the majority's attempt to apply a core immunity of its own making expands the concept of core constitutional powers beyond any recognizable bounds. The idea of a narrow core immunity might have some intuitive appeal in a case that actually presented the issue. This is similar to, I would argue, what Justice Barrett was saying. If the president's power is conclusive and preclusive on a given subject, then Congress should not be able to act upon the subject. In his Youngstown concurrence, Justice Robert Jackson posited that the president's power of removal in executive agencies seemed to fall within this narrow category. Other decisions of this court indicate that the pardon power also falls in this category. Quoting U.S. v. Klein from 1872, to the executive alone is entrusted the power of pardon, and it is granted without limit, as does the power to recognize foreign countries. See Zivotofsky v. Kerry from 2015, holding that the president has exclusive power to control recognition determinations. In this case, however, the question of whether a former president enjoys a narrow immunity for the exercise of his core constitutional powers has never been at issue, and for good reason. Trump was not criminally indicted for taking actions that the Constitution places in the unassailable core of executive power. He was not charged, for example, with illegally wielding the presidency's pardon power or veto power or appointment power or even removal power. Instead, Trump was charged with a conspiracy to commit fraud to subvert the presidential election. It is true that the detailed indictment in this case alleges that Trump threatened to remove an acting attorney general who would not carry out his scheme. Yet it is equally clear that the government does not seek to impose criminal liability on the president for exercising or talking about exercising the appointment and removal power. If that were the majority's concern, it could simply have said that the government cannot charge a president's threatened use of the removal power as an overt act in the conspiracy. It says much more. The core immunity that the majority creates will insulate a considerably larger sphere of conduct than the narrow core of conclusive and preclusive powers that the court previously has recognized. The first indication comes when the majority includes the president's broad duty to take care that the laws be faithfully executed among the core functions for which a former president supposedly enjoys absolute immunity. That expansive view of core power will effectively insulate all sorts of non-core conduct from criminal prosecution. Were there any question, consider how the majority applies its newly minted core immunity to the allegations in this case. It concludes that Trump is absolutely immune from prosecution for any conduct involving his discussions with Justice Department officials. That conception of core immunity expands the conclusive and preclusive category beyond recognition, foreclosing the possibility of prosecution for broad swaths of conduct. Under that view of core powers, even fabricating evidence and insisting the department use it in a criminal case could be covered. The majority's conception of core immunity sweeps far more broadly than its logic, borrowed from Youngstown, should allow. The majority tries to assuage any concerns about its made-up core immunity by suggesting that the government agrees with it. That suggestion will surprise the government. To say, as the government did, that a small core of exclusive official acts, such as the pardon power, the power to recognize foreign nations, the power to veto legislation, and the power to make appointments, cannot be regulated by Congress, does not suggest that the government agrees with immunizing any and all conduct conceivably related to the majority's broad array of supposedly core powers. The government, in fact, advised this court to leave potentially more difficult questions about the scope of any immunity that might arise on different facts for decision if they are ever presented. That would have made sense. The indictment here does not pose any threat of impermissibility, criminalizing acts within the president's conclusive and preclusive authority. Perhaps for this reason, even Trump discouraged consideration of a narrower scope of immunity, claiming that such an immunity would be nearly impossible to fashion and would certainly involve impractical line-drawing problems in every application. When forced to wade into thorny separation of powers disputes, this court's usual practice is to confine the opinion only to the very questions necessary to decision of the case. There is plenty of peril and little value in crafting a core immunity doctrine that Trump did not seek and that rightly has no application in this case. Okay. Fuck, my voice is dying. Jesus.
I am not a church.
When asked about the allegations that RFK Jr. sexually assaulted his then 23-year-old babysitter, his answer,
I am not a church boy. I am not running like that. I said I had a very, very rambunctious youth. I said in my announcement speech that I have so many skeletons in my closet that if they could all vote, I could run for king of the world. Mm-hmm. So, this Vanity Fair is recycling 30-year-old stories, and I'm not, going to comment on the details of any of them. But
give me the full interview real quick. I don't believe that this was his response to that specific question. There's no shot.
I am who I am.
You're talking there about the nanny situation. I mean, I do have to ask her. I mean, are you denying it or not?
I'm not going to comment on it.
All right. Well, I gave you the opportunity.
Have you ever debated Sagar and Jetty? No. I don't know how to pronounce his name even. I got a DM from this, I'll just say Beth. I don't even know who this person works for. About doing an RNC debate in Milwaukee on July 19th. What is this related to? Is there like an event or something? Or is it like a Republican thing? Or waiting for her to respond to that. But okay. All right. I'm going to shower and stuff and go downstairs and get ready for anything else. Wait, this is the interview?
Joining me now is
On a whitewater trip many years ago on the Fu River, they say there's an expert. They have an expert that has identified that as a dog carcass.
yeah.
It's just not true. So, and in terms of the other allegations, I've said this from the beginning. I am not a church boy.
I'm going to give you a chance running on short time.
I think it's $47,000, maybe $43,000 per donor. So it allows us now to go back to our donors and our maximum donors and tell them that that there's a new maximum. And so I think our fundraising is gonna be fine.
All right. Last question for you, sir, because I know that you're running on short time. Vanity Fair came out with a major profile today. I want to give you a chance to respond to this. There's a photo circulating, I believe, of you posing with what looks like a dog, and also a barbecued dog. I'm not going to show the picture as a dog lover. I know you have pets yourself, and also a sexual assault allegation from one of your former nannies. So I want to give you a chance to respond to that.
Yeah. Sorry. The article is a lot of garbage. The picture that they said is of me eating a dog. It's actually me eating a goat in Patagonia on a whitewater trip many years ago on the Fu River. They say there's an expert. They have an expert that has identified that as a dog carcass.
Yeah.
It's just not true. So, and in terms of the other allegations, I've said this from the beginning. I am not a church boy.
Oh my God. It was actually the worst answer possible. He did answer it. He was presented with two allegations: a photo of you eating a dog and a claim that you sexually assaulted somebody. And his response was to specifically reject the dog eating allegation and then to hand wave the other one. Wait, why would you do that? Jesus Christ. He should have just given this response to all of the allegations instead of rejecting now I think he did rape somebody. Why would you do that? Why would you explicitly reject one and then just leave the other one hanging there?
I am not running like that. I had a very, very rambunctious youth. I said in my announcement speech that I have so many skeletons in my closet that if they could all vote, I could run for king of the world. Mm-hmm. So, this Vanity Fair is recycling 30-year-old stories, and I'm not, going to comment on the details of any of them, but I am who I am.
You're talking there about the nanny.
I am who I am. I mean, 30 years ago when he was 22. I don't even listen. I don't give a fuck. I don't care. I don't give a fuck. Well, I mean, if he full on raped somebody, I would give a fuck. That's pretty bad. But to just say that I'm a wild boy, I am who I am, I'm unapologetically me, and sometimes that just might be a rapist. That's a wild statement to make. Christ. Click on the picture of the dog eating. Nah, I don't need that shit. Okay. Thread explaining. Oh, do I want to read this Noah Smith thing? Thread explaining. For everything partisan coded, 80% of people will lie through their teeth to serve their tribe's goals, so it'll be hard to find an impartial summary of today's presidential immunity SCOTUS opinion. But I don't have a tribe, so here's my just the facts. Okay, I want to do this. Remember, this month we're being boring, so lots of reading, and I'm being better on my note taking. Hopefully, in the hopes that we can do better videos. So my goal after we finish reading the decision, I'd like to be able to do a video on it where I summarize the decision. I give good questions to ask for people that disagree with me, force them to answer these questions. Commentary on opposing points of view. I'd also like to include 3 different points of view that I want to address that I disagree with. So it'll be this. It'll be the Ben Shapiro video. Are you doing scripted content? No, it won't be scripted, but I'll just like talk through it in a more, because right now it feels like the only way to get like my opinion on any of this shit is like, oh, go watch this 8-hour stream on the Supreme Court thing, basically. Yeah. What am I looking for? Ben Shapiro, YouTube.
Well, last night was the first.
Jesus. Wait, did he change the title of this?
It was Justice Roberts who saved Obama.
SCOTUS makes a decision and the left goes insane.
Does not have immunity.
Probably has A/B testing on? Yeah, sure. Okay. How long is this? Fuck. Executive immunity has always been a thing. The underlying rationale is that presidents cannot be encumbered in carrying out their necessary official duties with fear they will be sued. Executive immunity has always been a thing. Excuse me, what? But immunity from what? Clearly, it hasn't always been a thing. If in Nixon v. Fitzgerald, the court had to grant it, and criminal immunity obviously hasn't been a thing if it was granted in this recent case right now. So I don't believe this is true. I don't know what he's sourcing to here. In terms of official acts, the president may act 1 with constitutional powers reserved, powers shared between or delegated by others, or 3 neither. Presidential immunity is strongest category 1, non-existent. Okay, who is this guy a lawyer? It's not strongest in category 1. It's absolute in category 1. What does this guy do? Attorney, programmer, student of life. Okay. He's just wrong here. I don't know if he didn't read or... Well, I guess if I'm being very technical, it is the strongest in 1 and the weakest in 3, or non-existent in 3. If by strongest you mean that's when it's absolute and unquestionable. That is the strongest thing, I guess. Technically, I guess. Presidents have total immunity. Okay, I'm sorry. He says it in the next thing. Okay. Okay, so it is, never mind. He is correct. It's just a strange way to phrase that. Presidents have total immunity in category 1. Otherwise, it would give Congress and the judiciary power over the executive in an area where it is supposed to have exclusive power. This opinion focuses on category 2, where Congress delegates or shares power with the president. The other actions relevant here is whether proceedings are civil or criminal. The president's official acts, which encompass both categories, are absolutely immune from civil money damages lawsuits. Well, from all civil lawsuits, right? In terms of criminal law, though, we have far less clarity. We have no clarity. SCOTUS today laid out the tension. The president needs to be able to act within the scope of the office. SCOTUS said today, taking into account these competing considerations, what is presumptive immunity? It's a presumption that a president is immune from criminal prosecution for official acts. But that presumption can be rebutted with a showing that prosecution wouldn't violate separation of powers. Wait, is it true that it wouldn't violate the separation of powers, or if you can show that it wouldn't encumber the executive to act? I don't believe this is true. I'll do a more formal go over this tomorrow, but I think this part is not actually correct. But SCOTUS today said, well, or maybe what he's saying here is another interpretation of what I'm saying, but SCOTUS today said the president has at least presumptive immunity. The majority said whether immunity here is presumptive or absolute is not a question that needs to be resolved today. In essence, today's decision kicks that can down the road. Up until now, I've only talked about SCOTUS opining on presidential immunity generally. What does that mean for Trump's case specifically? Well, this may seem strange, but nothing really? What? The key question for Trump's case is whether Trump's conduct around January 6th was official conduct. SCOTUS says the lower courts haven't adequately addressed that, and SCOTUS can't address the questions on its own initiative. It can only review lower court findings. And so SCOTUS goes on to analyze the alleged conduct to assess whether and what conduct qualifies as official conduct, but with the caveat that it can't do so comprehensively because it doesn't have a comprehensive record. SCOTUS addresses Trump's alleged conduct in 4 buckets: challenging election results in court, leaning on VP Pence to thwart certification, leaning on state officials and private parties to change state election results, and Trump's speech on and around January 6th. Bucket 1, SCOTUS says this conduct is absolute immunity. The executive is given sole authority to investigate and bring cases. If you could get around this by saying the cases were shams, every challenge to presidential judgment in bringing cases would claim as much. I don't like the way that he's summarizing number 1. I would full stop disagree with this. SCOTUS addresses Trump's alleged conduct in 4 buckets. 1 is challenging election results in court. That it wasn't about challenging election results. It was about appointing people in the attorney general role. It was about hiring and firing for his office, for his offices that are underneath him. It wasn't about challenging election results in court. The example given by Roberts was the threat to fire the attorney general if he didn't basically push a sham investigation through. So I disagree with the example given here. SCOTUS says his conduct has absolute immunity. The executive is given sole authority to investigate and bring cases. If you could get around this by saying the cases were shams, every challenge to presidential judgment in bringing cases would claim as much. This doesn't even make sense. The executive is given sole authority to investigate and bring cases. I don't even know what he's talking about here. I don't know where he got any of this from. I'm not sure what this, I don't know what any of this means or where any of this comes from. Bucket 1, SCOTUS says this conduct has absolute, okay. Bucket 2, SCOTUS says VP presiding over certification is generally not executive function, but some VP acts presiding over Senate may be. SCOTUS instructed lower court to determine whether prosecution of these grounds would intrude on executive function. Says VP presiding over certification is generally not an executive function, but some VP acts presiding over Senate may. That's not really what he said, what Roberts said there either. Roberts said that, Roberts was talking about President Trump talking to Vice President Pence about the proceedings. Bucket 3, SCOTUS says president doesn't have authority over states' elections. They suggest finding me 10,000 votes and plots to replace state electors aren't immune, but they admonish the lower court for not giving them a full record to assess other conduct in this bucket. What? No? What? I don't think they admonish it. They remand it back to the court to do a factual finding to address which acts of Trump were official or not official. I don't think they admonish the lower court for that. This wasn't even a question that they would have known they would have had to address. Bucket 4, SCOTUS says some presidential speech is squarely official conduct. Other presidential speech isn't, and it's a very fact-specific inquiry, and so the lower court needs to do the fact-finding to determine precisely for each of the things Trump was alleged to have said. In sum, presidents are absolutely immune when investigating and bringing cases. Presidential immunity is shaky at best. It was about hiring. I don't know where I don't even know if Roberts ever even says investigating and bringing cases. It was about hiring and firing for the attorney general. Next, SCOTUS makes clear that if the court determines he has immunity for a given act, he cannot face criminal prosecution for the act. They also add that acts cannot be considered by the jury when prosecuting the president for other non-official acts. Finally, SCOTUS considers and rejects Trump's far broader argument for immunity. Trump's team argued that he can't be prosecuted for anything unless he is first impeached and removed forward. SCOTUS has no textual support for this argument. That his Senate commentators all over social media are decrying this decision and saying that this decision would allow the president to assassinate his political opponents using SEAL Team 6. There's absolutely no support in the majority opinions for this. You're just wrong. SCOTUS could and likely will rule further on immunity, but I don't know. I don't know if he like chat GPT'd the ruling and then gave his summary based on that. Because when did the ruling come out? Is this Twitter thread like an hour or two after the ruling was made? I don't know. Okay. Whatever. Okay. I'll see you tonight. Peace.